Good day. My name is Jeffrey Margolis, and I am the lead administrative law judge in this morning's hearing. In response to the COVID-19 state of emergency, the Office of Tax Appeals will be conducting this hearing electronically with the agreement of all parties. Some of the participants today may be participating by computer, others only by telephone. Nevertheless, these proceedings will be broadcast live on the Office of Tax Appeals YouTube channel, and a certified shorthand reporter will transcribe the proceeding. Because these proceedings are being broadcast live, any confidential information shared on the screen is publicly viewable. So please do not share any social security numbers, credit card numbers, and the like, unless you are willing to have them be publicly disclosed. The transcript and the video of this recording become part of the public record and will be posted on the Office of Tax Appeals website. During today's hearing, we ask that you say your name before you speak. This is especially important because some of the participants do not have a video feed. We also ask that you do not attempt to use the chat feature in Webex if you are using Webex. If you can, we also ask that you mute your microphone when you're not speaking to avoid feedback and background noise. Although right now there does not seem to be a problem with that, which is good. From time to time, technical difficulties may arise. For example, you may not be able to hear. If this occurs, try to get my attention. For those on the video, you can wave your hand, say something, and then we'll try to fix the technical issue. If one of the ALJs or the OTA itself loses its connection, we may have to have a short recess, and we will try to reestablish the connection. So please just wait online or however you're connected, and we will try to rejoin you. If you do have any issues about rejoining, please contact Claudia Lopez at the telephone number that you've been provided with. With that, Madam Court Reporter, let's proceed to go on the record. Okay, that's fine, Lynn. We are now on the record. My name is Jeffrey Margolis, and I am the lead administrative law judge in the appeal of Ayaz Khan, OTA case number 1804-2861. The date is September 30th, 2020, and the time is approximately 11 a.m. I am joined here in this electronic hearing by my colleagues, administrative law judges Kenneth Gast and John Johnson. Although I will be the lead administrative law judge for purposes of conducting today's hearing, all three of the judges will have an equal responsibility for and an equal say in deciding this appeal. Will counsel for the parties please identify themselves for the record, beginning with appellant's counsel?
Yes, for appellant, this is Michael Halleck.
Is there anyone else appearing on behalf of appellant as counsel? Mr. Halleck?
No, I will be the only one appearing as no. Mr. Schultz and Ms. Yi will also be here appearing as counsel, although they will likely not be speaking during the hearing.
Okay, thank you very much. And who will be appearing for the respondent?
Respondent represented by Brian Miller.
And Mr. Miller, are you the only attorney appearing today on behalf of the Franchise Tax Board?
No, Sonia Woodruff is number two.
Okay, great. Let's proceed and make sure we agree on the issues to be decided today. It appears that the issues to be decided today are whether appellant remained a California resident throughout 2013 and whether he is liable for the late filing penalty as determined by the Franchise Tax Board. Is that a correct statement of the issue, Mr. Halleck?
This is Mr. Halleck. I agree regarding the residency issue. Regarding the late filing penalty issue, we will not be arguing reasonable cause on that issue, and we will be willing to concede the late filing penalty as it applies to appellant's California sourced income, though not to the Saudi Arabian income. So essentially, we are willing to concede. The part we don't concede goes away if we win. We don't concede the part that lives and dies on the residency issue, but we concede the part as it applies to the California source income.
Okay, thank you for that concession. Mr. Miller, was my statement of the issue correct?
Yes, your statement of the issue is correct.
Okay, and before the end of the day, I may have some questions about the credits in the taxpayer's account. We can get to that later, the $500 credit and the computation of the penalty, but we'll get to that at the end of the day here. I understand there's 4 witnesses, Mr. Halleck, is that correct?
That is correct.
And they're all available today?
Yes, Your Honor, they're all here.
Great, thank you. The parties agreed on most of the facts, and they agreed that most of the documents that the parties have submitted are admissible. I greatly appreciate the cooperation of Mr. Miller and Mr. Halleck. It makes everyone's job much easier. Also, per the pre-hearing conference minutes and orders, various objective facts alleged in the appeal letter and in appellant's father's affidavit have been admitted as true. As for the documents, we've sent out a hearing binder and we renumbered some exhibits. I assume that both sides got that. And my records show that the parties have agreed that except for the declarations, direct declarations attached as exhibits 17 through 19, appellant's exhibits 1 through 16 may be admitted into evidence. Is that correct, Mr. Miller?
It's 17, 18, 19. Yes, that's correct.
Okay. And then as far as respondents' exhibits, and also, by the way, those exhibits include various translations of 2A, 3A, 8A, 13A, 15A, and 15B, Mr. Miller.
Yes. Yes, we have those, and yes, those are acceptable.
Okay. Respondents' exhibits that were discussed at the pre-hearing conference were exhibits A through V, and Mr. Halleck had no objections to those exhibits, is my recollection. Is that correct, Mr. Halleck?
Yes, that's correct. I had no objections.
And respondent provided 2 new exhibits, W and X, 15 days or more before the hearing. They are IRS wage and income transcript and what was exhibit X?
Voter registration.
Oh, voter registration information. Mr. Halleck, do you have any objection to those documents being admitted?
I do not, Your Honor.
Okay. The documents that we've just discussed will all be admitted into the record as evidence. Yes, Mr. Miller.
Clarification. The objective facts of 1 through 13 on appellant's opening brief. So as the order says, the objective facts of 1 through 13. But the legal conclusions and subjective facts that are embedded in 1 through 13, I do not agree to. There are not many.
I think there were some statements of intent. I'd have to go back and look at them if you want to wait for a second.
Yeah, there's not much, but a couple points to make, yes.
Okay. Let me go to your brief for a second. Just bear with me for a second. So we're talking about his appeal letter.
Yes, and there's points 1 through 13 that we discussed at the pre-hearing. And I agreed to the objective facts with him.
Okay, and so which statement of fact did you were you concerned that was not an objective fact?
In number 5, I agree that he began work on June 1st, 2013. However, the other things, I found work with an indefinite end period. That is not an objective fact. And the purpose for leaving was my work, which goes to intent. So that's not an objective fact.
Is that your only Okay, with that qualification, is there anything else in facts 1 through 13?
Yes, just a second. In number 13, we agree. Yeah, 13, he established social connections and relationships, but the second part is subjective. I had no intention. It goes to intent.
Okay, I did not, it was my understanding that that second sentence did not qualify as an objective.
Yes, sir.
fact.
This is
With respect to statement number 5, perhaps Mr. Halleck, perhaps your client could just testify to that during the hearing, and he can establish those facts or in that manner. Is that satisfactory to you?
Sure. I believe he will be testifying that. Although I don't think that I think that an indefinite end period, is an objective fact. And I don't. These objections were not raised during the pre-hearing conference regarding its factual points, and so we're relying, on the statements of intent within, in our arguments, and so I believe that they should be admissible.
Mr. Miller, what's your response with respect to item 5?
Item 5?
Yes, with respect to
whether or not
number 5.
Right, whether or not he found work with an indefinite end period. There's no objective evidence of that.
Well, it's still a statement of an objective fact. I'm going to find that you've admitted that fact. You're free to cross-examine Mr. Khan on that. With respect to the second line in finding number 13, statement number 13 in the brief, that I had no intention to ever establish residency in California again, that is specifically the kind of statement that I did not believe qualified as an objective fact, and that he can testify to that, Mr. Halleck. So that is not, we're not accepting that as an evidentiary fact based upon this statement.
I understand, Your Honor. I've been planning to raise that in my argument. I'll do my best to remove that and rely only on what he says in his testimony regarding that. Thank you, Your Honor.
Okay. And with that, let's move forward. We've said that each side will have 5 minutes for an opening statement, and then we'll have witness testimony, including test questions from the FDB and by the judges if they have any, and then we'll allow a closing argument by each side of 15 minutes and a 5-minute rebuttal by appellant. So let's begin with that schedule. Mr. Halleck, you have 5 minutes for your opening statement. You may begin whenever.
All right. Thank you, Your Honor. The evidence today will show the following. Dr. Ayaz Khan was living in California at the outset of 2013. In January 2013, his ex-wife, Anush Khan, filed for divorce in the San Bernardino Superior Court. They had been separated since September 22, 2011. Dr. Khan had long-standing family and religious ties to Saudi Arabia, and he decided to make a fresh start there. His plan was to live in Saudi Arabia indefinitely. He had no intention to establish residency in California again. Shortly after the divorce began, Dr. Khan began cutting ties with California. On February 11, 2013, he sold one of his cars. On May 20th, he emptied his storage unit. On May 24th, he transferred his other vehicle to his ex-wife. Dr. Khan had already terminated his California lease on August 31st, 2012. At the end of May, Dr. Khan moved to Saudi Arabia, and on June 1st, 2013, Dr. Khan began work as an ophthalmologist at Maghrabi Hospital in Saudi Arabia, where he continued working through the end of the year at issue. Dr. Khan's colleague from Maghrabi Hospital, Dr. Al-Kasas, is here today. After Dr. Khan moved, he continued using his parents' address in California to receive mail, but he did not reside there. After he moved, Dr. Khan took many steps to establish himself as a resident of Saudi Arabia. He rented an apartment with a 2-year lease. He purchased a new car. He closed his bank accounts in California and opened overseas bank accounts. Dr. Khan obtained a Saudi residence permit, driver's license, and credit card. Dr. Khan also obtained a Saudi medical license and Saudi malpractice insurance. He took all these steps with the intention of living and working indefinitely in Saudi Arabia. In July 2013, in Saudi Arabia, Dr. Khan befriended Ahmed Al-Najar, who is also here today. Ahmed Al-Najar and Dr. Khan became good friends, and became good friends after Dr. Khan performed eye surgery on Ahmed Al-Najar's mother at Maghrabi Hospital. Dr. Khan and Ahmed Al-Najar saw each other frequently during Ahmed Al-Najar's long visits to Saudi Arabia. After befriending Ahmed Al-Najar, Dr. Khan met Noor Al-Najar, Ahmed's sister. They began to see each other in Saudi Arabia regularly through the end of the year at issue. Dr. Khan and Noor Al-Najar are now married. Noor Al-Najar is also here today. Ayaz Khan's accountant mistakenly filed a California resident income tax return for him for the year 2013. Dr. Khan realized this error, contacted his accountant, and attempted to correct this error and file an amended return on February 16, 2016, well before the FTB issued the notice of proposed assessment pertaining to his 2013 residency on June 26, 2017. The facts will show that once Ayaz Khan moved to Saudi Arabia, he ceased to be a resident and domiciliary of California and became a resident and domiciliary of Saudi Arabia. That concludes my opening statement. Thank you, Your Honor.
Mr. Miller, you may proceed with your opening statement.
Morning, judges. The evidence will show that appellant was a California resident during the entire 2013 tax year. Under Revenue and Taxation Code Section 17014, a person domiciled in California who is outside the state for a temporary or transitory purpose is a California resident. There is no dispute that appellant was a California domiciliary during all of 2013, and no dispute that he was a California resident from January through May 2013. Appellant now contends, after reporting on his 2013 return that he was a California resident, that he abandoned his California domicile, was a non-resident of California during the disputed period of June 2013 through December 2013, because he claims he was outside California rather than a temporary purpose, with no intention to return. However, the evidence shows otherwise. The evidence will show that appellant was employed abroad for about a year and that he returned to California in July or August 2014 with an expired Saudi medical license and an expiring Saudi work visa. There is no objective evidence that appellant returned to Saudi after August 2014, such as a renewed residency permit, medical license, or employment agreement. The evidence will show that appellant returned to California during the summer of 2014 and practiced medicine in this state while simultaneously claiming that he was permanently absent. The evidence will show that appellant maintained his California medical license during his year in Saudi in preparation for his return to this state. The evidence will show that appellant maintained significant ties to California while he worked abroad. His children lived in this state, and he visited them here. He maintained his California driver's license. He appeared in California courtrooms. He used his parents' California address for his California income tax returns, driver's license, and voter registration. In summary, the evidence will show that appellant did not sever his consequential connections to California while working abroad and maintained significant ties in readiness for his return. His maintenance of these connections demonstrates that his absence from June 2013 to December 2013 was not for other than a temporary purpose. Because the evidence does not support appellant's contention that he was absent for other than a temporary purpose, appellant was a California resident during the entirety of 2013. Thank you.
Okay, thank you. Mr. Halleck, you may call your first witness.
Yes, Your Honor. This is Michael Halleck. The first witness is Ayaz Khan.
Mr. Khan. Do you solemnly swear or affirm that the testimony you provide today will be the truth, the whole truth, and nothing but the truth? You need to unmute your microphone to answer.
Okay, I do, Your Honor. Good morning, and
Okay. Yes, we can hear you fine. Mr. Halleck, proceed.
All right, thank you, Your Honor. Okay, Dr. Khan, I'm going to ask you some questions now. Dr. Khan, were you living in California at the beginning of 2013?
yes, I was.
And were you getting divorced at that time?
Yes, I was.
Okay. Could you tell the panel a little bit about the history of that separation and divorce, please?
My ex-wife and I separated on September 2, 2011. Back in 2011, filed for divorce on January 31st, 2013, after I was moving to Saudi Arabia. She knew I was planning on moving. All my belongings. She asked the court to not allow me to take the children out of the country. And
Okay, thank you.
you know,
All right, thank you, Dr. Khan. Okay, so you decided to move to Saudi Arabia? Okay.
yes, so I decided to move to Saudi Arabia. I had made the decision sometime in early
Could you repeat that, Mr. Khan? You made the decision when?
leasing a house in early 2000 and in the summer of 2000. And my parents allowed me to live with them for a few months until I finally left. Due to delays on my overseas licensure and work start date, I didn't leave until the last week of May 2013. On June,
Okay.
I was in.
Okay. Okay, so why, and just to be clear, why did you decide to move there?
I'd always wanted to move there. I have the holiest city in my religion, Islam, and a few days at a time as a vacation. And I felt there indefinitely. I had a difficult marriage, and I wanted to break free from the past and focus on my spiritual growth. The ex-wife agreed with my plans and filed for divorce on January 31st, 20.
Okay, thank you. And so had you lived there before in Saudi Arabia?
I have. So my parents and siblings, I was younger. My younger sister was born there. My father is a retired civil engineer who spent a large part of his career working there. He was a U.S. citizen, and then he moved there, and he was working there. And my younger sister was born there. I was born while my father was working there also. I happened to be born in Pakistan, but that's because there wasn't a hospital in the city that my father was working at in Saudi Arabia at the time. So after I was born, a few weeks later, we were back in Saudi Arabia, and I was there until 1985.
Okay, thank you. Okay, so how long did you intend to live there?
So for me, it was indefinitely. This was an indefinite move, and I didn't have any plans on returning to California.
Okay, thank you. And so you did not intend to return to California?
I did not, but I had in the back of my mind that the ex-wife would not, send the kids. I knew no California court would allow, especially in a contested divorce, no California court would allow the children to go overseas. So I had mentally prepared that I would have to return in the summers and visit. So that was a possibility that I was aware of.
Okay, but you didn't intend to establish residency in California again?
Absolutely not.
Okay, you didn't intend to move back there on any sort of long-term basis?
No, not at all.
Thank you. Okay, so given all that, what steps did you take to get ready to leave California?
So I stopped renewing the house I was renting. 2009 all the way to 2012, I had been renting. From start 2000 came up, I stopped because I had already been making these arrangements. My licensure had not started in Saudi yet, and work arrangements had not made yet, so I didn't quite leave in time. But that was one where I stopped renting. I owned 2 cars for many years, and they were bought brand new by me. I sold both of them in 2013, or I sold one and then transferred the title of the other to the ex-wife. And so I got rid of my ownership in both cars right before I left. I had my things in storage until May 2013, just 4 or 5 days before I left California. And I was renting a storage locker for about a year and a half, and I had my things in there, and I got rid of it right before my departure. So I sold all my things that I had in storage in California, and I had no intention of coming back. Once I reached Saudi Arabia, I got a 2-year lease on an apartment. I bought a brand new car. I didn't lease one. I bought a brand new one. I started attending religious gatherings, daily mosque gatherings. I joined the ophthalmology society meetings. I established work there, and and my social connections there.
Sure. All right. Thank you, Dr. Khan. And so when did you actually move to Saudi Arabia?
So on May 31st, 2013,
All
and
right.
I was in Saudi Arabia June 1st working.
Great. Thank you. And so, so you were employed there?
Correct.
All right. Who was your employer?
My employer was Maghribi Eye Hospital.
Okay. And when did that start?
So June 1st, 2013.
Okay. Thank you. And could you tell the panel just a little bit about the nature of your position there?
I'm an eye doctor, so I was working as an eye doctor over there.
Okay. All right. Thank you. And so were you employed in this position for the remainder of 2013 after you moved?
Yes, I was.
Okay. Thank you. Outside of work, I believe you just mentioned it, but just to be clear, did you attend meetings for any professional societies in Saudi Arabia?
I did. So the Saudi Ophthalmology Society and the Emirates Ophthalmology Congress, both of those meetings I had attended in 2013.
Okay, thank you. And did you attend meetings for any religious organizations in Saudi Arabia in 2013?
I did, daily mosque gatherings.
Okay, thank you. Did you form any other social connections over there?
So I met lots of friends and family there, some of them who you'll meet today. My most important social connection is my wife, Noor Al-Najar. I met her in 2013 while I was there, and we developed a relationship, and we eventually ended up getting married this year.
Thank you. Okay. And did you return to the United States at all in 2013 after you moved?
I did not.
Thank you. Okay. Turning to a few final questions. In 2013, were you using your parents' address at 2035 Calle Francesca in San Dimas to receive mail in California?
Yes, I was.
Okay. And why were you using that address?
So I was in the midst of a contested divorce and needed a mailing address to be served and a central place in the United States to gather all my important documents. I have always used my parents' address as a mailing address, even while I attended residence in New York. While I was there for 3 years, I always had my parents' address as a mailing address. I've leased separate homes from 2009 to 2012 while living in California, not living at my parents' address. And again, I was always using my parents' address as a mailing address, as just a central place to collect my mail.
Okay.
My tax returns were, filed with the 2035 Calle Fran, even in previous years when I was not living at my parents' address.
I see.
So I've had frequent moves over the years. And
Okay, thank you. And were you living at all at that address?
I was not.
After you moved? Okay.
After I moved, I was not living at that address.
Okay, thank you. Just a few more questions. Did you vote in 2013, either in California or Saudi Arabia?
I did not.
Okay, and did you own any property in 2013?
I did not.
Did you take a homeowner's property tax exemption in 2013?
I did not.
And did you have any business interest in California after you moved to Saudi Arabia?
I did not.
Okay, thank you very much, Dr. Khan. No further questions, Your Honor.
Mr. Miller, do you have any questions of the witness? Can't hear you, Mr. Miller.
No questions for this witness.
Okay. Let me ask my co-panelists if they have any questions for Mr. Khan. Judge Gass, do you have any questions?
Thank you. This is Judge. One question for Mr. Khan. FTB submitted Exhibit W, and it indicates that you received compensation from California Laser Eye Associates in 2013 of about $6,000. Can you address that compensation?
Yes, sir. That was earned prior to my move. I have been working as a locums, doing some locums work just prior to my move, and that was earned early in 2013. Actually, probably half of it was earned in 2012, and they ended up paying me in 2013. But all of that is related to work prior to my move.
No further questions.
Judge Johnson, do you have any questions?
Judge Johnson, I have no questions. Thank you.
I have just a few questions. Mr. Khan, I couldn't hear sometimes. So when did you, I know you moved in May of 2013, but when did you make the decision to move to Saudi Arabia?
Probably about April or May of 2012 is when I started communicating with, trying to look for work overseas. So right about then.
And was
But that's of 2012. Sorry.
I'm sorry, what's that again?
That April, May of 2012 is when I first started communicating with prospect employers overseas.
So more than a year before you actually made the move, correct?
Correct. Yes.
Okay. And did you have social and family connections in Saudi Arabia before you moved there, as well as after?
I did. I've developed friends over the years from visiting. I have a Dr. Lawrence Brown who actually lives in Medina, who I got to meet several times even before I moved there. As I stated, my family actually used to live in Saudi Arabia with me, until 1985. And after we moved to the United States, we were U.S. citizens, but my parents were still living there. After we moved back to the United States, later in 1999 to 2006, my father and mom again went back to Saudi Arabia. My dad continued working there as a civil engineer. And so I used to visit frequently. So it's a place I've developed an attachment to, especially the city of Medina. I probably wouldn't have gone.
Okay, and one final question. Your employment agreement with the hospital in Mughrabi, I think, I probably butchered the name, but your employment agreement overseas, was that for a fixed amount of time, or was that an indefinite agreement?
It's an indefinite agreement.
Okay. I have nothing further. In light of my questions, does Mr. Miller, do you have any additional questions?
No further questions.
Mr. Halleck, do you have any additional questions?
No further questions. Thank you, Your Honor.
Okay, Mr. Halleck, you may call your next witness.
Okay, my next witness is Noor Al-Najar.
Yes.
Ms. Al-Najar, do you solemnly swear or affirm that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
This is Noor Al-Najar. Yes.
Okay. Please proceed, Mr. Halleck.
All right, thank you, Your Honor. All right, Mrs. Al-Najar, could you please tell your story now?
What was that question, Mr. Halleck?
I asked her if she was going to go ahead. We agreed that she was just going to tell her testimony in a narrative form. So I was just asking her to go ahead and tell that.
Okay, that's fine.
Your Honor, it appears she's muted, or at least she was.
Ms. Al-Najar, can you unmute your microphone so we can hear you?
Yes.
Okay, that's better. Talk loud, please. You can proceed with your testimony.
Yes. I'm Noor Al-Najar. This was the applicant for Ayaz case. I grew up in Saudi Arabia. I was living in Medina in 2013. I introduced to Ayaz Khan when he was the surgeon for my mother in her carrot surgery in July 2013. After the surgery, my brother Ahmed Al-Najar became friends with Ayaz Khan. Ayaz Khan and I started to see each other in social family gathering. It started in July 2013. Due to the friendship with my brother Ahmed, Ayaz and I began to relationship in October 2013. We saw each other about once every couple weeks. From October 2013 until July 2014, when he left to Saudi Arabia for visit to see his children. After he returned to Saudi Arabia, September 2014, we continued to see each other about every 2 weeks until Ayaz moved back to United States. In January 2015, most of our meeting was at home with family or outside in restaurants. We also meet gathering between our two families in Medina every few years, few months between July 2013 and January 2015. Ayaz's stay in Medina, our plan was to getting married in Medina and living over there in his apartment. Ayaz rent a large apartment, and he has a car, his own car over there in Medina, which we plan to live in close from our family, my family in Medina. After Ayaz moved back to United States in January 2015, our relationship continued. I moved to United States when my visa approved in early 2020 this year. Ayaz Khan and I were get married on June 7, 2020. I did clear understand briefly of perjury, this forming true and correct.
Thank you, Mrs. Al-Najar. No further questions, Your Honor.
Record, I'm not living with him anymore.
Mr. Miller, do you have any questions?
I do not have any questions for this witness. Thank you.
Okay. Mr. Judge Gass, do you have any questions for this witness?
This is Judge Gass. I do not have any questions. Thank you.
Judge Johnson, do you have any questions?
That's Judge Johnson. No questions. Thank you.
Okay, I don't have any questions either. Mr. Halleck, you may call your next witness.
All right, thank you, Your Honor. Next witness is Ahmed Al-Najar.
Present.
Mr. Ahmed Al-Najar, do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
Yes, I'm Ahmed Al-Najar, I swear.
Okay, thank you. Mr. Halleck, please proceed.
Thank you. Yes, okay, Mr. Al-Najar, you can go ahead, please, and tell your story now.
Good afternoon, everyone. My name is Ahmed Al-Najar. Ayaz used to be my brother-in-law. I grew up in Saudi Arabia, where I first met him in 2013. He did the surgery for my mother at Maghrabi Hospital, and we became friends. I saw Ayaz later that day when he did the surgery for my mother during Ramadan, and we became friends, and we've been visiting each other since then. After we were introduced, I saw Ayaz 5 to 7 days a week for the duration of my trip to Medina, whenever I go to Medina. And Ayaz would eat breakfast and meals with me and my family, or otherwise I would bring food to his home as he was living by himself, or we would go to a restaurant or have social gatherings together. I also saw Ayaz performing a cataract surgery on my mother as well as his father. During our time together in Medina, Ayaz and I would be hanging out with each other, and he expressed that he would like to stay in Medina permanently. He told me that following his divorce, he was hoping to find a spouse and establish a family in Medina. He rented a large apartment with multiple bedrooms and purchased an SUV with 7 seats. During my time in Medina, Ayaz and Noor, my sister, has begun a relationship. This relationship continued after Ayaz returned to the United States in 2015. Ayaz's sister got married in 2020 this year. I declare under penalty of and perjury that this was the truth.
Thank you, Mr. Al-Najar. No further questions.
Mr. Miller, do you have any questions of this witness?
I do not have any questions for this witness.
Judge Gass, do you have any questions?
This is Judge Gass. Any further questions?
Judge Johnson, any questions?
This is Judge Johnson. No questions. Thank you.
Okay, I don't have any questions either. Mr. Halleck, you may call your next witness.
All right, thank you, Your Honor. All right, next witness is Ahmed Al-Kasas.
Mr. Al-Kasas, do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may proceed, Mr. Halleck.
Thank you, Your Honor. All right, Dr. Al-Kasas, could you please go ahead and tell your story now? Thank you.
Okay, I'm Ahmed Al-Kasas. I'm a former colleague of the appellant in this case, Ayaz Khan. I am an ophthalmologist at Maghrabi Eye Hospital, Jazan, Saudi Arabia. In 2013, I was employed as an ophthalmologist at Maghrabi Eye Hospital in Medina. Maghrabi has hospitals in both Jazan and Medina. Ayaz Khan became my colleague at Maghrabi Hospital in June 2013. He worked with me as an ophthalmologist. I would see Ayaz Khan at work at Maghrabi Hospital at least 5 days per week, from June 2013 until he left the hospital in January 2015, except when he visited his children in the United States briefly in summer 2014. We would also eat at restaurants together about once per week during that period. We would also socialize outside work. On our days off, we once took a trip to Mecca and also went fishing together about 3 times. I also helped Ayaz Khan to locate an apartment in Medina and purchased a car in July 2013. When he searched for an apartment, Ayaz told me that he was planning to stay in Medina indefinitely. He said he wished to marry a woman in Saudi Arabia following his divorce and bring his children to Saudi Arabia if it was possible. We found a large apartment because he said he wanted an apartment suitable for a family. He also purchased a large car, a 7-seat Toyota Sequoia, because he said he was going to need a family car there.
Thank you, Dr. Al-Kasas. No further questions, Your Honor.
Mr. Miller, do you have any questions of this witness?
Excuse me. I'm sorry. I don't believe he's finished. He just signaled that he was not finished.
Oh, okay.
So,
I finished already.
okay, I'm sorry. I thought he made a signal that he had not finished. I'm sorry.
No, just there's some messages coming over my cell phone on.
Mr. Miller, do you have any questions of this witness?
I do not have any questions for this witness. Thank you.
Judge Gass, do you have any questions?
This is Judge Gass. I do not have
Judge Johnson, do you have any questions?
Judge Johnson, no questions. Thank you.
Okay. I don't have any questions either, but in going through my notes, I do have two questions I'd like to ask the taxpayer, Mr. Khan, if it's not too late, which I'm saying it's not. Mr. Khan, you talked about the mailing address. I'm just wondering, how long does it take to get mail that's sent from the United States to Saudi Arabia, if people had to send their mail directly to Saudi Arabia? Can't hear you.
It's actually surprisingly quite difficult in Medina. The mail does not get delivered to the actual house address. It actually goes either to your employer's address, or it goes to, you have to get a PO box at like the local post office. There's one in the city, and it's a difficult process to actually get your mail. The easiest is probably at your employer's office, but I had a lot of private stuff going through a divorce and stuff like that, and I didn't want all these private mailings happening there. Also, my ex-wife needed a proper place to serve me and send me documents related to the divorce, and I've always had that California address. It's always been easy. My brother was living there, and it was always easy to get documents sent to me when I needed them.
Okay. And there's an allegation in your brief that when you applied for a Saudi driver's license, you had a choice of a 1-year driver's license, a 5-year driver's license, or a 10-year driver's license. And you got the 10-year driver's license. Was that more expensive? Was that more expensive than the 5-year or the 1-year?
Yes. It's about, you can ask Dr. Al-Kasas also, but I don't remember the exact price, but it's about double or triple the price of, maybe quadruple the price of the 3-year license or something. So, and it actually comes out to 9 years. It's actually not 10 years. It's just a little under, but it was the maximum extent license.
Okay. In light of those questions, does Mr. Halleck or Mr. Miller, do either of you have any further questions of this witness?
I have no further questions. This is Michael Halleck.
I have no further questions. Brian Miller.
Okay. Mr. Halleck, is that your last witness?
It is, Your Honor.
Are you ready to provide us with your closing argument?
I am, Your Honor. May I go ahead?
Yes, please proceed.
All right. Thank you, Your Honor. All right. The issue here is whether Dr. Khan remained a California resident throughout 2013. Dr. Khan did not remain a California resident throughout 2013. Rather, he was a part-year resident. He cut ties with California and established new ties with Saudi Arabia and was a Saudi Arabian resident and domiciliary, and no longer a California resident and domiciliary from that point onward. The OTA's pending presidential appeals of Mazur proposes 2 alternative tests which can determine California residency. The first test is that for an individual not domiciled in California, were they in California for other than a temporary or transitory purpose. The second test is that for individuals domiciled in California, whether the individual is outside California for a temporary or transitory purpose. Regarding the first test, Of course, the evidence and conceded points 1 through 13 from the pre-hearing conference established that Dr. Khan was not present in this state from June 1st, 2013 until the end of 2013. The FTB is not asserting he was present in California from June 1st through the end of the tax year for any purpose. Therefore, there is no issue of whether Dr. Khan was in California for a temporary or transitory purpose. He was not in California at all. So the first test definitely does not show Dr. Khan was a California resident. That means we are mainly arguing the second definition. Respondent is asserting that Dr. Khan was domiciled in this state and he was outside the state only for a temporary or transitory purpose. That is not true. He was not domiciled in California, nor was he outside California for a temporary or transitory purpose. To begin with, Dr. Khan was not a domiciliary of California from June 1st, 2013 onward. Per Mazur, an individual can have only one domicile, and domicile is defined as the one location where an individual has the most settled and permanent connection, and the place to which an individual intends to return when absent. Per Mazur, in order to change domicile, a taxpayer must actually move to a new residence and intend to remain there permanently or indefinitely. Per California Code of Regulations, Section 17014C, an individual who is domiciled in California and leaves the state retains his or her California domicile as long as there is a definite intention of returning to California, regardless of the length of time or the reasons for the absence. However, Dr. Khan moved to a new residence, Saudi Arabia, and he intended to remain there permanently. We discussed in point 13 of the conceded points at the pre-hearing conference that Dr. Khan had asserted in that point that he had no intention to ever establish residency in California again. It appears now that as a point of intention, that point was not conceded. However, he did assert that in that point. In addition, all witnesses today have also asserted, including Dr. Khan, that he intended to remain there permanently. In addition, Dr. Khan's work overseas had an indefinite end period. As he also obtained the maximum allowable length driver's license of 10 years, conceded in factual point 9. He also obtained a Saudi residence permit and a car, apartment, bank account, medical license, and insurance, all of which will be discussed further shortly. But all these facts support Dr. Khan's intention to stay in Saudi Arabia permanently. I reiterate to you, all witnesses, including Mr. Khan, have stated that he had no intention to ever establish residency again. For all these reasons, Dr. Khan was not a California domiciliary after he began work on June 1st, 2013. However, even assuming there is any doubt as to whether Dr. Khan changed his California domicile, he was not a resident of California once he moved to Saudi Arabia with the intent to remain there indefinitely. Per Mazur, the primary question is whether he was outside California for a temporary or transitory purpose. Per California Code of Regulations, Section 17014B, whether an individual is outside California for a temporary or transitory purpose is a question of fact determined by examining all the circumstances of each particular case. In the appeals of Mazur, the Office of Tax Appeals applied the closest connection test in determining residency, which takes into account the connections a taxpayer maintains within California and outside of California in determining whether they had a temporary or transitory purpose. The Office of Tax Appeals applied the Bragg factors in determining where the taxpayer had the closest connection. The appeal of Bragg provides a list of non-exclusive objective factors used to determine where an individual had the closest connection for the period in question. Mazur opposes the Bragg categories Mazur organizes the Bragg factors into 3 categories. The first category is registrations and filings with the state or other agency. Factors in this category include driver's license, automobile registration, address used in state of residence claimed on federal and state tax returns, voter registration and participation history, and homeowner's property tax exemption. Dr. Khan obtained a valid Saudi driver's license after he moved there and requested the maximum length of validity allowed there as stated in conceded point 9 and also shown in Exhibit 2. And he did not renew his California driver's license after he moved. In Exhibit F, FTB's driving record for Dr. Khan, it only shows he renewed his California license in 2016. It has no information about 2013. In any case, Dr. Khan replaced his California license with a Saudi Arabian one, and the Saudi Arabian one was the only one he used after he moved. He was driving on Saudi Arabian roads after all. Since Dr. Khan obtained a Saudi license and did not renew his California license, the driver's license factor supports Dr. Khan's non-California residency. In addition, Dr. Khan sold or otherwise relinquished his California registered vehicles before the date he left, shown in Exhibits 4, 10, and 11. After he arrived in Saudi Arabia, Dr. Khan purchased a new vehicle there, shown in Exhibit 3. Since he relinquished his California registered vehicles and obtained new vehicles overseas, the automobile registration factor supports Dr. Khan's non-California residency. Regarding the address on the tax returns, while Dr. Khan originally filed a California resident income tax return for 2013, this was due to a mistake by his tax preparer. Dr. Khan recognized this mistake and attempted to correct this mistake by contacting his tax preparer on February 16, 2016. This was 15 months prior to the issuance of the Notice of Proposed Assessment on June 26, 2017. This is shown in Exhibit 6. Dr. Khan did not express his intent through this mistakenly filed return. That doesn't make sense. Rather, the only time he expressed his intent was in asking his tax preparer to change it to reflect he was not a resident after he moved. Because the California resident return was a mistake and Dr. Khan tried to file a non-resident return, this again supports Dr. Khan's non-California residency. And regarding the California address Dr. Khan used, Dr. Khan continued to use his parents' address throughout 2013. The declaration Dr. Khan's father included, which is in the binder as Exhibit 7, explains that Dr. Khan had long used this address and continued to use it after he moved overseas, which is understandably convenient, but he did not reside at this address after he moved. Finally, Dr. Khan did not vote in 2013, either in California and Saudi Arabia, or take a homeowner's property tax exemption in 2013. For these factors in the first brag category, the evidence shows that Dr. Khan created new overriding connections overseas from the ones that he had in California. The second brag category is personal and professional associations. This category includes employment, bank and savings accounts, memberships in social, religious, and professional organizations, maintenance and ownership of business interests, professional licenses, ownership of investment real property, and presence, connections, and residency is indicated by third-party affidavits and declarations. Regarding employment, after he moved, Dr. Khan was only employed at Maghrabi Hospital in Medina, Saudi Arabia in 2013, per his own testimony and Dr. Al-Kasas' testimony. This employment was for an indefinite period, as he has stated. He was not employed in California during the latter half of 2013. Since he worked in Saudi Arabia but not California during the period at issue, this factor supports Dr. Khan's non-California residency. Regarding bank accounts, FTB has conceded that Dr. Khan both closed his California bank accounts prior to moving in point 11 and opened bank accounts overseas in Saudi Arabia shortly after moving, shown in conceded point 10. Because he both closed his California bank accounts and opened new ones overseas, the bank accounts factor clearly supports Dr. Khan's non-California residency. Regarding religious organizations, once in Saudi Arabia, Dr. Khan attended a mosque per his own testimony. Regarding professional organizations, he also attended meetings of the Saudi Ophthalmological Society per his own testimony. These religious and professional organizations support his non-California residency. And as far as business interests go, Dr. Khan maintained no business interest in California after he moved, so the business interest factor favors his non-California residency. Regarding professional license, as I have mentioned, Dr. Khan obtained an overseas professional license after moving, shown in Exhibit 8. Of course, I don't think many doctors would go to the trouble to actively cancel their California medical license after moving. Nonetheless, Dr. Khan obtained an overseas license which supported his work after he left. Therefore, the professional license factor supports Dr. Khan's non-California residency. In terms of real property, Franchise Tax Board has conceded that Dr. Khan did not own any investments or real property in California after his move in point 12. So the investments in real property factor supports Dr. Khan's non-California residency. And regarding presence by third-party declarations, there are three third-party declarations in the hearing binder which are to be considered for admission in the event any of today's witnesses were not present. Those witnesses are here today. These witnesses' testimony and declarations show Dr. Khan's physical presence, social connections, and residency in Medina, Saudi Arabia from June 2013 onward. In Exhibit 17, Respondent has also conceded that Dr. Khan established social connections overseas in point 13 of the factual points referenced in the minutes and orders. So the third-party declarations factor supports Dr. Khan's non-California residency. The third and final brag category is physical presence and property. This category includes location, values, and sizes of residential real property, where the taxpayer's spouse and children reside, origination point of the taxpayer's checking account and credit card transactions, and number and general purpose of days the taxpayer spends in California versus other states. Again, FTB has conceded that Dr. Khan did not own any property in California in point 12. However, he did rent a home in Saudi Arabia once he moved there, shown in Exhibit 15 and described in the testimony. Therefore, the property factor supports Dr. Khan's non-California residency. Regarding Dr. Khan's spouse and children, appellant was in divorce proceedings from his spouse at the time, shown in Exhibits 1 and E. Appellant's children were in California at this time, but this was not his decision. The evidence shows that Dr. Khan's ex-wife had initiated the divorce proceedings, as shown in Exhibit 1, and the terms of the custody prevented them from visiting him overseas without his ex-wife's permission, shown in Exhibit 12. There is just no way he could have had his children overseas with him in Saudi Arabia in that time frame, given the constraints of his custody proceedings. Regarding credit cards, Dr. Khan maintained a credit card with a Saudi bank shown in Exhibit 16, which supports his non-California residency. Finally, Dr. Khan did not spend any time in California in 2013 after he moved to Saudi Arabia for any reason per his own testimony. Since he spent all his time in 2013 overseas after he moved, and not in California, the number of days category supports Dr. Khan's non-California residency. If one looks at the Bragg factors, the totality of the evidence in each of these three categories is simply in favor of the appellant. One more point on Mazur. In Mazur, the Office of Tax Appeals concluded that the appellant was a California resident and domiciliary. One point the panel focused on was the appellant's purpose in leaving being for employment purposes. I would like to note the respondent has conceded at point 5 that the purpose of Dr. Khan's leaving California was not for work purposes. So Dr. Khan is not similarly situated as the appellant in Mazur. While the appellant in Mazur had a family who stayed in California after they left, and that appellant left only for a temporary employment contract, the facts here are clearly different. Dr. Khan was in the midst of a divorce, and his employment contract overseas was indefinite. While the appellant in Mazur intended to return to his family in California once the employment contract ceased, there is nothing to suggest that Dr. Khan intended to return to California on a permanent basis. And in fact, he has not returned to his ex-spouse and instead has married a woman who he met in Saudi Arabia. Therefore, per Mazur and the Bragg factors, Dr. Khan did not maintain the closest connection with California after he moved in 2013. Rather, he maintained the closest connection with Saudi Arabia at that point. At that point, he was no longer a California resident. To sum up, as I have stated, Dr. Khan became a Saudi domiciliary after he moved. In any case, Dr. Khan maintained the closest connection with Saudi Arabia after he moved. Therefore, Dr. Khan did not remain a resident of California throughout 2013. He ceased to be a California resident after he moved and began his work there. Therefore, I respectfully request that this appeal be granted. That concludes my closing. Your Honor, are you able to hear me? I'm not sure I'm able to hear you. I think your microphone may be off. I'm sorry.
Okay, you can hear me now, I hope. Okay. I have one question, Mr. Halleck. There's one point you made in your argument I just didn't quite follow. You said that he did not renew his California driver's license during 2013. Is there anything in the record saying his license came up for renewal during 2013?
I do not believe there is, Your Honor.
Okay, I just wanted to make clear.
Yes.
Mr. Miller, can you provide your closing argument?
Okay. Morning, judges. Under Revenue and Taxation Code Section 17014, a California domiciliary who is outside the state for a temporary or transitory purpose is a California resident. Section 17014 also states that a person who is a resident of California continues to be a resident of California, even though temporarily absent from California. A non-resident of California is a California domiciliary who is absent from this state for other than a temporary purpose. Now, until now, appellant had not challenged it, had not claimed that he changed his domicile. But appellant was a California domiciliary when he departed California to work in Saudi Arabia, California domiciliary while he worked in Saudi Arabia, and a California domiciliary when he returned in 2015. A person's domicile is where he has his most settled and permanent connection, the place to which he has, whenever absent, the intention to return. Residence, on the other hand, is a place of some permanency, more than a mere temporary stay. To change domicile, one must physically move, then manifest an intention to remain there permanently. A clear indication that California was where appellant was most settled and had his permanent home is the undisputed fact that he was a domiciliary of the state before departing to Saudi for employment, and when the employment was completed shortly thereafter, he returned immediately to California. Also, appellant maintained his California medical license, his California driver's license. He never surrendered that, and his Los Angeles voter registration. Furthermore, and maybe the most important single item, is that his children remained here. Appellant has not demonstrated through any objective actions that he forever abandoned California and made Saudi Arabia his permanent home. He was not a Saudi Arabian domiciliary. Respondent has no doubt that appellant was a California domiciliary. Now, appellant contends that he became a non-resident of California in June 2013 because he left the state. Respondent disputes this. Now, appellant bears the burden to prove with the preponderance of evidence that his absence from the state from June 2013 through December 2013 was for other than a temporary purpose. This is as a California domiciliary, which is my position. As a preliminary matter, we should remember that a person can simultaneously be a resident of California for income tax purposes and be a resident of another state, including Saudi Arabia, for income tax purposes. Respondent has no position on whether appellant was a resident of Saudi Arabia for income tax purposes. At issue today is whether the evidence demonstrates that appellant's absence from California was for other than a temporary purpose. The evidence shows that appellant went to Saudi Arabia for employment purposes. First, appellant's authorization to be in Saudi was his residency permit, which is only valid as long as he was employed by the sponsor, Rabi Hospital. He was not allowed to be in Saudi for reasons independent of his employment. Appellant's Saudi medical license expired in May 2014, and his work visa expired in August 2014. He returned to California in July or August of 2014 as his authorization to live and work in Saudi expired. There is no objective evidence, such as a work visa, a medical license, or employment contract, indicating that appellant returned to Saudi after April 2014. We only have witness declarations and statements made to OTA more than 5 years after appellant returned to California. Second, appellant tells us in his reply brief that he returned to California when, in his words, the work situation had changed and hence I needed to move back to California. If appellant was allowed to be in Saudi Arabia for reasons unrelated to his employment there, he would not need to return to California when his work situation changed. Now, a California domiciliary who is absent for employment purposes can still be considered a non-resident. Under California's safe harbor provision, California domiciliary who is absent from the state under an employment-related contract for at least 546 consecutive days with a return to the state of no more than 45 days is considered to be absent for other than a temporary purpose. Presuming appellant began work abroad on June 1st, 2013, and returned to California June 30th, 2014, he was absent 403 consecutive days. If he returned on July 31st, he was only absent 434 consecutive days, which is short of the threshold. And even if appellant were employed abroad for at least 546 consecutive days. He reported on his 2014 income tax return that he returned to the state for 58 days, which exceeds the 45-day allowance. These statutory thresholds provide guidance to determine whether an absence for employment purposes is lengthy enough to be considered an absence for other than a temporary purpose. But taxpayers' failure to meet the safe harbor provision does not end our analysis. OTA's pending presidential opinion and appeal of Mazur states that it is particularly relevant in a residency case to examine whether a taxpayer who was absent for employment purposes has substantially severed his California connections and taken steps to establish significant connections with his new place, or whether, on the other hand, the taxpayer maintained his California connections in readiness for return. The Mazur opinion also recognizes the appeal of Bragg, a long-established Board of Equalization opinion, a case that identified connections that are helpful to consider when analyzing whether a taxpayer's absence from the state is for other than a temporary purpose. A very significant connection to the state was appellant's maintenance of his California medical license, which is a Bragg factor. Evidence demonstrates that he maintained this connection to California in readiness for a return to the state. Appellant tells us in his reply brief that he maintained his California medical license while he was abroad in order to return and practice medicine in California. Appellant returned to California in July or August 2014 and earned $34,101 from California Laser Eye Associates. Furthermore, appellant's California medical license was important enough that he even appeared in family court in 2014 telephonically to challenge his threatened suspension. So not only did he maintain his California medical license, but he exercised its privileges to practice in this state while simultaneously claiming that he was permanently absent from California. Now, appellant tells us in his reply brief that he maintained his California driver's license while abroad for his use while driving in this state. Appellant's presentation, his statement a few minutes ago, appellant's representative, said that there's seemed to imply that appellant surrendered his driver's license. That is not the case according to California DMV records, and this is backed up by appellant's own statements in his reply brief that he maintained his California driver's license. Appellant's own words inform us that he maintained this connection to California in readiness to return to this state. This is another connection to California that appellant maintained in readiness for his return to this state, demonstrating that his absence for the state was not for other than a temporary purpose. Another significant connection to California was his children, whom he visited. The state wherein the taxpayer's children reside is a Bragg factor, demonstrating a connection to the state. Appellant also maintained his active California voter registration, which is a Bragg factor and indicates maintained connections to the state even while absent. Now, appellant claimed California resident status on his 2013 using his parents' San Dimas address. He filed as a California non-resident in 2014 and returned to filing as a California resident in tax years 2015, 2016, and 2017. He's not filed his 2018 return yet, so we will see. The state of residence claimed by appellant on his returns is a Bragg factor. And in this case, appellant claimed he was a California resident with a California address during every year but 2014. Appellant used this address on his tax returns, his driver's license, and his voter registration. And finally, appellant lived in his parents' San Dimas house prior to his June departure to Saudi, according to his father's declaration and testimony today. And appellant's evidence indicates he returned to San Dimas at the conclusion of his employment in Saudi Arabia. Appellant tells us in his opening brief that he moved out of a rental in 2012, and he said that today, so he lived in San Dimas at least 5 months before departing to Saudi Arabia at the end of May. Appellant returned to California in July or August 2014 or January 2015. Appellant did not rent his own place until 2016, according to his Exhibit 14. Thus, the evidence points to his return to San Dimas at the conclusion of his employment in Saudi Arabia. Appellant severed some connections with California, but they're the sort of connections that are easily reestablished. He moved out of an apartment, which would be normal for a single person going abroad for a year. He emptied a storage locker, but discarding replaceable household goods is consistent with going abroad for a year. He sold a vehicle, which meant he did not have to store it here while abroad. While he was in Southern California practicing medicine during 2014 and appearing before family court, he must have had access to another vehicle, maybe a family member. Meanwhile, the connections appellant established in Saudi did not prove he was absent from California for other than a temporary purpose. He rented but did not purchase a house. He obtained a Saudi driver's license, which he needed to drive. He purchased a vehicle, which he needed for transportation. A dwelling and a vehicle are basic items that he would need anywhere, and they are not a significant connection to Saudi Arabia. The appellant makes much of the size of the rented house and size of his vehicle in his briefs, contending that he aspired to marry and raise a family in Saudi Arabia, and contends that this proves that he was absent permanently. However, he did not marry and did not start a family in Saudi Arabia. None of this actually happened. What actually happened was his extended family arrived in 2014 and lived with him in the large house. Appellant needed a large house and a large vehicle in anticipation of the family visit in the spring of 2014. Now, appellant met, and maybe he became engaged to his current wife while he was employed in Saudi Arabia. But appellant returned to California, leaving her there, and the couple did not marry until this year in California. Now, appellant contends that he went to Saudi intending to marry and raise a family there, but he returned to California shortly after meeting his future wife. Appellant did not demonstrate through his actions an intention to marry and raise a family in Saudi Arabia. Now, in OTA's pending precedential decision in the appeal of Mazur, recognizes that the connections a taxpayer maintains with this state are a measure of the benefits and protections the taxpayer received from laws and government of California. Regulation section 17014 explains that residency is intended to identify persons who are physically in the state enjoying the benefit and protections of its laws and government. Now, appellant practiced medicine while physically present in the state during 2013 and 2014. He benefited from California's advanced economy and medical infrastructure. In addition, appellant was protected by the laws of the state, including civil courts, while practicing medicine. Appellant also benefited from the use of California motorways when he drove here with a California driver's license and was protected by public safety agencies, insurance, and civil courts if he was involved in a crash. Appellant's voting rights were also protected by California law while he maintained absentee ballot registration in Los Angeles. Appellant also benefited from the laws and government of California and the dissolution of his marriage and determination of parental custody of his children. He made at least 2 personal court appearances in this state. Appellant also appeared in court in 2014 to challenge a pending suspension of his California medical license. In conclusion, appellant maintained significant connections with California, even as he claimed to be absent for other than a temporary purpose. His hold on significant connections with California, including practicing medicine, his children's presence, maintaining a driver's license, and voter registration, failed to demonstrate that appellant's absence from this state was for other than a temporary purpose. Appellant was a California resident during all of 2013. Thank you.
Thank you, Mr. Miller. Before you do your reply, Mr. Halleck, I have one question for you, Mr. Miller, about Dr. Khan's maintaining of his California medical license. Is there anything in the record to show that the maintenance of that license required some activity by Dr. Khan during 2013, or was it just a passive maintenance as far as the record goes? Do we know?
I do not know if there are fees attached, like for the California bar, but there is a status. One can essentially suspend the license for a period of time. So one can affirmatively go in and deactivate, make his license inactive for a period of time. Or if
Okay.
someone's not going to be here, they can always withdraw.
Okay, thank you. Mr. Halleck, are you ready to provide us with your reply, your rebuttal argument?
I am, Your Honor. May I start?
Yes, you may.
All right. First of all, regarding domicile, FTB, appellant has never conceded domicile. FTB says in their brief that appellant did not protest this, and they seem to imply today that's a concession. But there nowhere in the record will it show that appellant conceded that issue, nor would he knowingly have done that with his knowledge of the law and the issues. It just doesn't make sense. Regarding the FTB's discussion of the ability of the appellant to have residency in multiple locations, I just want to mention that in Mazur, they say the OTA states that the underlying theory of section 17014 through 17016 is that the state with which the person has the closest connection during the taxable year is the state of her residency, which seems to be saying that a closest connection is something that can usually be found. And in this case, I think the facts definitely show that the closest connection was with Saudi Arabia. But anyway, getting to the evidence, frankly, the Franchise Tax Board has got nothing here. If you look through their evidence, it consists of evidence showing Dr. Khan maintained a California medical license, evidence of appellant's California divorce proceedings, voter registration form, driving registration form, a whole bunch of tax returns and income transcripts, most of which are not from the year at issue, a few documents related to this appeal, like the notice of proposed assessment, a web page about Saudi Arabia, and an FTB law summary. And that's it. All they have is evidence that Dr. Khan maintained a California medical license, registered to vote, had a divorce in California, and filed as a resident in 2013. Concerning those tax filings, I've explained that Dr. Khan and his accountant have stated this was a mistake, and in the evidence, there are letters which show that. And Dr. Khan tried to fix this mistake. Regarding the other years that FTB brings up, I was under the impression that each tax year stands on its own. And we have already stated that, that he returned in 2015. The issue here is 2013. And at that point, his intention was not to file as a resident. I think that's clear. Concerning his medical license, Dr. Khan had a medical license in Saudi Arabia during this time, as I stated. And I don't believe many doctors would voluntarily contact their state's medical board just to rescind their own license. I'm not an expert on this area, but I believe it's the same price to keep the license active as it is to deactivate it anyway. So there's not really an incentive for someone to deactivate it. Regarding voting, as I mentioned, Dr. Khan did not vote in 2013. Anyway, regarding driver's license, respondent says that the appellant has used the California roads, but that would have to only have been before he moved, which was not at issue. We're not saying that he wasn't a resident in the beginning of 2013 when he was driving. We're saying he was not a resident after he moved, and there's simply no way he could have been driving on those roads at that time. The FTB's contention, I'm sorry, I heard a beep. Is everyone able to hear me? Okay, all right. Anyway, the FTB's contention that Dr. Khan's divorce and custody proceedings and the presence of his children in California that would show his residency is frankly ridiculous. First of all, this divorce was filed in January 2013 before Dr. Khan left. And Dr. Khan was still a California resident when this divorce was filed. We know he was a resident then. He changed residency after he moved and established himself overseas. It's unreasonable to expect him to switch these divorce proceedings to Saudi courts at that time. Also, I'm not sure of any law that says that court proceedings are dispositive or even relevant in these cases. Regarding his children, we all know that the courts of California would not have allowed Dr. Khan's children to come with him to Saudi Arabia in the midst of these divorce and custody proceedings. Respondent has also brought up the fact that he came back in 2014. That was a visit that he made to see his children, and all the witnesses say that he returned to Saudi Arabia after the visit. He returned until 2015. Nothing in the record show that he did not say otherwise. So he returned to see his children and see his kids. Then he returned to his residence and domicile of Saudi Arabia for the duration of 2014. Anything that he did there is insignificant to the amount that he did in Saudi Arabia during that year. Meanwhile, ultimately, all the brag factors that I've discussed are overwhelmingly in the appellant's favor. The Franchise Tax Board wants you to believe that their few pieces of evidence show Dr. Khan just meant to make a temporary stay in Saudi Arabia. However, we have far more evidence which shows that Dr. Khan moved to Saudi Arabia and lived there for the duration of the tax year with the intention of living there indefinitely. It seems to me that based on the most recent precedent in Mazer, the Office of Tax Appeals must resolve in favor of the appellant. And with that, I conclude my rebuttal. Thank you, Your Honor.
Okay, thank you very much. I have one, this is not a question so much as a comment. There was some argument about a $500 credit in taxpayers' account that was apparently an overpayment from the 2012 year that was claimed on its 2013 year, according to, I think that was footnote 31 in Respondent's brief. We don't really deal with payments and credits in the context of our decision, but I just want to make sure that Respondent and Appellant's counsel take that into account in the recomputation of any penalty liability. I'm not sure whether or not that payment would be, if that was in the account at the time the tax return was due. I believe, I'm not certain, that might be that might reduce the amount of the penalty in terms of how much of a deficiency there was. Again, we don't have the information about the payments and the credits in the account, but please be aware of that when the final deficiency computation is made. That's all I'm asking. Mr. Miller, do you have a question?
Yes, this just goes back to one of your earlier questions. You asked me about the medical license, and I just informed quickly that it's renewable every 2 years. So one doesn't have to permanently. Thank you.
Okay. Is there anything else from you, Mr. Halleck?
There's not, Your Honor.
Okay. I want to thank you both for presenting your arguments very well today. Both sides did. And also want to thank you very much for your pre-hearing cooperation regarding the exhibits and stipulations of fact. We'll take the matter, we'll close the record and take the matter under submission. And we will issue an appeal, our decision in this matter in 100 days, inshallah. So thank you all very much. And this concludes the hearing. We'll resume at 1 o'clock.
Thank you. The record is closed on the Khan appeal, right?
Yes, it is.